I've put the rules there. Was part of it. So in the rules, you'll see there are forms at the back of the rules. Form 17 basically gives you an idea of what the notice of motion should look like, the normal one. So every application, unless it's a ex parte application, would normally look like that. So you can go to page 17. So you will see the rule says it must be served on the registrar, and if there's a party who's either an interested party or against whom relief is sought, that person must also be served. Now, if you look at the notice of motion, you'll see at the bottom there's space indicated, which says to, and then it says respondent's legal practitioner or respondent. At this point in time, when you are issuing your notice of motion, there would not be a legal practitioner normally, unless beforehand the intended respondent had basically consented to his legal representative receiving service on his behalf. So this is a process initiating proceedings, notice of motion. Okay. So when we start off, the applicant will have to serve on the respondent through the deputy sheriff. Okay, not serve on a lawyer unless there has been consent given by the respondent beforehand that his papers may be served on his legal representative. So the general position would be you will have the notice of motion with all the relief, etc. The applicant will sign, or the applicant's legal representative will sign. It will be addressed to the respondent, and then you'll see on the second page of the form, it will also say to the registrar. Before the new rules, the registrar didn't have to sign the notice of motion in order to issue it, as far as I remember, no? Yeah. But now, in terms of the new rules, the registrar has to sign. So it can be signed by the registrar before the notice of motion is served on the respondent or after it has been served. So when the rules started out, there were some people who were clever, and if the papers are served without the registrar having signed the notice of motion, they will bring Rule 61 proceedings and say that it's irregular. You discussed irregular proceedings as well? Okay. So I did that too. But we just didn't want to deal with that application. But it's not irregular to serve the application before it's signed by the registrar. But the application must be issued by the registrar. So you know that there's the e-justice system. So everything that comes now, everything new will be done through the e-justice system and would invariably be issued and signed before service. Okay. When we talk about so it's easier when we're talking about a person against whom relief is sought. Normally you will ask for relief against a party. Okay? You will ask for relief, which will require another party to do something or not do something or refrain from doing something, etc. in an application. Sometimes you are not asking for relief against a particular party, or you have relief against, for instance, a government official, like a minister or somebody from a parastatal, the Manpower's board or whatever. You're asking for relief against them. But whatever relief you are asking may have impact on another party. So this will usually be in reviews, for instance, where an administrative official has taken a decision. So you've gone and you have applied, you have submitted a tender, You were unsuccessful. You were not the only tenderer in this process. There was somebody else who was successful. Obviously, with a tender, there's more than one tenderer. So there were the other persons who had also submitted tenders. They also have an interest in what you might be asking in this application. So you come to court, you have a review, and you say, I want that decision to award the tender to Nelly and Nelly's company to be set aside, and I want the minister to, or I want the tender board to rather award the tender to me. So now Nelly is the one who was successful. She is an interested party. I'm not asking for relief against Nelly. I'm only asking for relief against the tender board. But Nelly is an interested party because what are you trying to do? You're trying to take the tender away from her. So she needs to be cited as a party to the application, and she needs to be served with the application. Okay. So it's a party against whom relief is sought, as well as anybody who's interested in whatever, has an interest in whatever relief you seek. Otherwise, you will be faced with a non-joinder application. And then the court might dismiss your application because it cannot grant an order which will affect another person without having that person before it in court. So Nelly might decide she's not interested in opposing this application. So she doesn't file an opposing affidavit. But at least the court knows she received the papers. She has had an opportunity to decide whether she wants to oppose or not. She chose not to oppose. So she has assumed that risk of whatever order the court makes. But if I don't serve Nelly, the court doesn't know whether Nelly would want to oppose or not. Okay. Although court documents become public once they've been in court, it doesn't mean that it would necessarily come to the person's knowledge because it's not necessarily published in a way in which everybody gets sight of it. So that's why the court, or why the rules expect you to serve every interested party. Okay. So the locus classicus on what is an interested party is the Amalgamated Engineering Union case, which is also referred to a lot in our jurisdiction. It has South African references, but before 1990, it remains part of our jurisprudence. Okay. Then you have an ex parte application. So ex parte means that you are not seeking any relief of a final nature against anyone. You specifically are not bringing this application to this person's attention for various reasons. Either it's so extreme that you cannot serve it on this person, or it's one of those kinds of applications that even if you serve it on the person, they are not capable of responding to it because they are not of sound mind. That's the curator ad litem or curator bonus applications. Those ones you will not serve, you will not give notice to the other party, you only address it to the registrar. Okay, now there's a difference between the types of ex parte applications that you can bring. Even if you are not seeking any final relief against a person, you are looking for interim relief. It's not final in nature, but you are seeking relief against somebody, but it's interim of nature. But you do not want this person to know that you are busy with because they might defeat the object of the purpose of your application. So for instance, I know Nelly might run away with a car if I serve her with the application. So I first want to get the order to prevent her from taking the car out of the country. She must be referred to in the papers. Her name must be appearing on the papers, but I don't serve her with it. So that's a different kind of application for our ex parte application. In those circumstances, the court will give the person an opportunity to come back to court at some point. So the court will only issue a rule nisa. We'll deal with that a little later. So let me use a different example. So you want to bring proceedings against a company, for instance, and you suspect that they might destroy documents. Okay? So there's a particular application that you can bring in order to prevent them from doing so, because you need these documents to prove your case. Very extreme relief that you are seeking, and you come in an extreme way to court on an ex parte basis. So you will come to court without giving that person notice, meaning that you do not serve the application on that person. It would normally be on an urgent basis, and you will you must always give notice to the registrar. The registrar must always know about your case. The registrar will be there. But you will come to court and you will get interim relief. You might get an order for the deputy sheriff to to collect the papers that you need from this person. The court will not give a final order. It will give a rule nisi with interim with immediate effect, in the sense of, yes, the deputy sheriff can go take the documents from this person and keep it with him to safeguard the papers, because otherwise it will be destroyed. Now, if you give this person notice of your application, what's going to happen? They're going to destroy the documents, and then you would have defeated the purpose of what you were trying to achieve. So they won't get notice, but they will appear as a respondent on the papers. So if you look at Form 17, you have, I don't know why it says plaintiff and defendant. It should actually read applicant and respondent at the top there. So yeah, I thought I had a normal notice of motion here. But even if let me just show you. Yeah. So here you had one applicant and many respondents. So this is what I had as an example of an urgent application, but an urgent application will have the same format. So you have the Marero Royal House is the applicant, and the Red Flag Regiment is your first respondent, and then the rest follows. So a lot of these people, some of them might not have, you might not be asking for relief against all of them, but you're citing them because they have an interest in the case. That's a normal notice of motion. But then you have an ex parte application. I'm not sure if I have one here. Okay, so here's an ex parte application. It's for a curator ad litem. Okay, so this person, Mara van der Merwe, I'm saying that she's not of sound mind. So even if we serve the papers on her, Mara won't even know what we're talking about, okay, because of a mental disability or whatever. So she's mentioned, but she's not a respondent, as you can see there. She's mentioned because we are just indicating what is the purpose of this application. So there's just an applicant. James is the applicant, and the application is for the appointment of a curator ad litem to Mara van der Merwe. So she's not cited as a respondent here. Okay, that's the one ex parte application. The other one is not really ex parte, but it's called ex parte because you're not serving it on the other party. Yeah. So it's not ex parte in this sense that I have here. So that person will be there that respondent will be there, but you will not serve it on him. What you will serve on him later on, after you've gotten your order and you are now capable of serving the order on him, you will serve the order together with all the papers on that person when the deputy sheriff goes there to go and safeguard the documents, get the documents. Then that person will have an opportunity, in terms of that order, the court will say, if you do not want me to make this final, you must come back to court on a specific date, but the rules also allow you to come earlier as a respondent. We'll deal with those later on. Okay. So this is your normal, ignore that urgent notice of motion. Your normal one will have this appearance. So it's not exactly like this. This will, for instance, be on the right-hand side, and there will be other things there. Okay. So I've said here, with an urgent application, there will be long form or short form. There's no more short form in our jurisdiction. In the old rules, you would have a short form notice of motion, which would not have a certain part to it. So it will just end at number 4, and then it will just say this. Whereas the normal application will have this part to it. It will indicate to the respondent when they must oppose, when they must file their answering affidavit, and then they must put in an address, etc. Okay, so that would normally be at the end of a normal application. In the old rules, it made provision for a short form affidavit application, which didn't have this part to it. It just ended saying kindly place the matter on the roll, and that's it. And then it sort of leaves the room open for that person to determine when he's going to file his answering affidavit. We'll deal with that when we deal with urgent applications. Okay. So the court must also look at these things. We sometimes forget about this, okay? So for government, the government has more time to oppose applications. I think they have... Does anybody have an answer for me? 21 days, there we go. Okay. Whereas another applicant will have less days. 14 days to file the answering affidavit. Okay. Let's just go back again. Okay, the rest, pretty much, it must be issued by the registrar, it must be signed, dated, stamped, and then issued a case number. So before the application can be served, there must be a case number, otherwise the respondent won't have a case number to deal with. That's what happened under the old rules, because the registrar didn't have to issue or didn't have to sign and so on. You often found that the application, once you receive it, does not have a case number and that kind of thing. So the rules have changed slightly to deal with these little things. So with the e-justice system, sometimes things take a bit longer. The registrar might not be able to. So I'm not sure exactly, but once you feed it into the system, does it automatically give it a case number? You might get cases where people don't put it in the system. I don't know how they do it, and then they go. So sometimes funny things happen. We get two notices of motion in one application. You get the one, you see the system issues, so you feed in the prayers that you want, and then it issues a form basically with a notice of motion and with a summons. So it's not a PDF document. And then sometimes people will send you an application. You'll get this thing on the system, and then there's also a PDF document, which is their own, something that they generated, they typed up and so on. So, yes, people do funny things, but that's sometimes what happens. So it shouldn't actually happen that the application is unsigned before it's served, right? Okay, but it does. So, but by the time the matter comes to the court, there should be a registrar signature on it. Okay. I don't want to deal with the urgent application prayers now. So the notice of motion will really tell the court what is the relief that the person seeks. So the person is normally limited to what he seeks in there, but there's this little prayer that everybody adds at the end, which says further and or alternative relief And sometimes when you made a blunder and you didn't put in something that you should have done in your prayers, people will come and ask for the court to give further relief under that prayer, and it will obviously be opposed vigorously by the respondent. Your discretion would be, are the issues dealt with in the papers sufficiently for you to be able to give that relief anyway? And then if so, then you can. But the right way to deal with it is really for the applicant to amend the notice of motion to make provision for any further relief that he might seek. So as the case develops, maybe there's something in the answering papers that makes you want to amend your relief as an applicant, then you must file your notice of intention to amend and then amend. So what some people often do is to just file an amended notice of motion and then a point is taken, but the rule says if you want to amend, then you must first file a notice of intention to amend and then you can amend and so on. I still believe when it comes to a notice of motion, you should just be able to file an amended notice of motion, but it's probably better to do a notice to amend for the other party to be able to raise any objections that they want to raise, and then the court has to deal with an application for leave to amend. The reason why I say that you should be able to file an amended notice of motion without having to ask for leave to amend is because this deals with your relief really. It's not about your allegations and so on. So if it's taken care of in your affidavit, then I don't see why it should be an issue. But you might be faced with that objection, and then you must apply your discretion at that point in time. I think the later this amendment is brought about, the more necessary an application for leave to amend might become. So in those cases, so if it's close to the application, the parties have already filed all their affidavits and you now want to amend, and the respondent says, but I'm prejudiced by this amendment because if I had known that this is what you would have been seeking, then I would have dealt with it differently in my answering papers. Then obviously you have to consider whether this is so, whether there would be prejudice. And then the applicant will have to tell you and give you good reasons why you should amend the relief that they are seeking. Okay, so in applications, there are 3 sets of affidavits allowed. You can file further affidavits, but this can only be done with the leave of the court. So the person will have to apply for leave to file a further affidavit. So we've already sort of started talking about the affidavits. So it's founding affidavit, answering affidavit, and replying affidavit. Why you would need leave to file a further affidavit is because you need to explain to court why could you not deal with it in your previous affidavits. And this brings us to what must be contained in your affidavits. We've started talking about the essential averments. Okay, so depending on what kind of relief you seek, what are the requirements that you must meet in order to be successful with that relief? Let's talk about an interdict. Final interdict, you need to have a right. You must then make allegations about this right that you have. So you must, in your affidavit, provide the evidence of this right. So if you say, for instance, you have entered into an agreement with somebody, what you are seeking is specific performance of an agreement, You entered into an agreement with the respondent for the sale of a house. You bought his house from him. Immovable property, the agreement must be in writing. Then you have to produce the agreement. So it's not just saying in the papers, we entered into an agreement. You must also attach the agreement to the application to prove the agreement, because it must be in writing. If it's an oral agreement, then it's different, because obviously you can't attach anything. But with, or if the agreement may be done orally, say for instance it's a different thing that you bought, it's a car that you bought, then you can do it by way of an oral agreement. But if you say that it was a written agreement, then you must provide proof of the agreement. Because if the other party comes and says, no, we never entered into an agreement, then now, are you going to come and attach it now in your replying papers? Can you? Okay. So, you want now specific performance. You must now also, in your affidavit, you must say, I paid the purchase price. Or I have provided the guarantee in terms of the agreement. This is what the agreement's term says. I must pay a deposit. Here's proof of the deposit. I must provide a guarantee by a certain time. I did. Here's proof of the guarantee. Or maybe the time has not come yet for you to provide the guarantee, and you must tender the guarantee to say, I tender the guarantee. It will come whenever it's supposed to come. Okay. Then the affidavit, as I said, it contains facts and the evidence that you rely on in support of your case. And the same applies to the respondent. For his defense, he must provide the evidence that he's relying on. Because in application proceedings, the discovery process is very limited. We will get to that later. So everything, all the evidence that you rely on in order to prove the essential averments that you need to make in order to succeed with whatever case you've come to court, that must be there. All documentary evidence, if it's photographs, and that kind of stuff, you need to attach it. Lorraine, you wanted to say something? Is it time for our break? Okay, thank you. Okay. It's a good time to stop.